Yes. Hello. Hello. Okay. And the video stop peka start hai madega.
Yes, sir.
Hello?
You can.
Hello?
Yes, sir. This is Viral.
Yeah, so David, can you hear me?
Yes, sir. I can hear you,
Yes, hi.
and your even video is clear. Yeah.
Okay.
So for
Okay.
meanwhile, sir, you can
just tell me
unmute.
when to start.
Yes, sir. Yes, sir.
Okay.
We'll start
Yes.
at 4 sharp, and till now, till then, you can unmute yourself. You can
All
mute
right.
yourself.
Okay.
Yeah, yeah,
All right. Okay.
yeah, yeah.
Good morning, Santosh sir.
Can you hear me?
Yes, sir. Yes, sir.
All right, wonderful. How are you?
Bas, I am good. How are you?
Good, good.
Thank
Tell
you
me
so
when to
much,
start.
sir. Thank you so much for accepting our invite. Actually, I'm going to
Pleasure.
address at the end. So, yeah.
Pleasure. Where is your college situated in Bombay?
So, it's in Kandivali West.
Kandivali West.
Yes, sir. So, where you stay?
I stay in Kolhapur. I also practice in Pune, Kolhapur and Pune.
Okay, Kolhapur and Pune. Yes, Viral told me last time. But so you are coming to Bombay or like for
Yes,
any place
yes.
you
For
come?
some matters, yeah. Yeah.
Okay, sir.
Ma'am, till what time should we start? Like the participants are still joining.
Yes, still joining. You can ask sir if sir is okay in waiting for 5 minutes, so we can wait for 5 more
Yeah, we
minutes.
can wait. No problem.
Okay,
Okay.
We can
okay,
wait.
sir. Okay, sir. I've put the
So,
message on WhatsApp.
so I'll just unmute myself. You just tell me when to start and when you want to start.
Yes,
Okay?
sir. Yes, sir.
Yes,
Yes, sir.
sir.
Yeah. Yeah.
Ma'am, should we start?
Yes, I think we can start now.
Yes.
Let the participants join for the next half an hour. It's okay.
Okay, ma'am. Sir, with your due permission, I am starting.
Yes, sure. You can hear and
Yes, sir. There is a slight disturbance, but we can hear you. Uh, so a very good morning to all the people who are present here, the participants, our guest speaker who is joined with his, giving his due time to our webinar, Principal Ma'am, and all the teachers. I welcome you all to our two-day webinar as far as navigating the complexities of consumer laws in India are concerned. We have divided our webinar into two parts, that is into a series of 2 days. On the first day, that is today, we are going to speak about the history of consumerism, how the old act was passed. There were certain amendments which were proposed, but they were not taken up as far as the old act of 1986 is concerned. Apart from that, sir is also going to throw light upon the salient features and some important definitions and case laws as far as the Consumer Protection Act 1986 is concerned. As far as tomorrow's session is concerned, sir is Advocate Patwardhan is going to join us as a guest speaker, and he is going to talk about as far as the practical aspect of consumerism is concerned, how consumer redressal forums work, how to practice there, and he's also going to address the new amendment, the features of the same, and the discussion about the same as far as the 2019 amendment to the Consumer Protection Act is concerned. As we all are aware now, the way we deal and buy goods has changed. So now, from actually going to the shops and buying the goods, we have come up upon the artificial platform from wherein virtually we are online buying the goods, and there may be redressals which may come up because what you see may not be what you get. So in all these cases, how these issues are covered as far as the 2019 amendment is concerned, that also we are going to address through our webinar. I hope you all will enjoy the flow of information and knowledge that we are going to get as far as this 2-day series is concerned. With this, I want to give certain instructions as far as the participants are concerned. The participants, kindly don't unmute yourself while the session is going on. Also, kindly take care that your videos are off. And if you all have any questions, then you are supposed to put it in the chat box, and at the end of the session, once sir is done as far as his session is concerned, thereafter we will take up all the questions which are there, or if you want to ask at that time, you may be unmuted, and thereafter you can put forth whatever questions you all have. With this, I would like to invite Nikita Patil ma'am to introduce our today's guest. Nikita ma'am?
Yeah. Hello, am I audible?
Yes. Yes, you are audible.
Thank you, ma'am. It's my indeed privilege and honor to introduce the speaker for today, Advocate and Professor Dr. Santosh A. Shah. Sir has pursued Masters in Political Science from Fort Hays State University located in USA. He has pursued LLM from Temple University in the year 1991. He has pursued PhD in law under the guidance of Dr. Satyaranjan P. Sathe from Pune University. During his academic and professional career, Sir has won many awards and scholarships, to name a few. He stood first class first at the LLB final examination, by virtue of which Sir received number of prizes, awards and honors inclusive of a gold medal. He was included in the Dean's list of students at Temple Law School, Philadelphia, USA. He was selected for All-American Scholar, Who's Who Directory and Who's Who among international students in United States. He was a recipient of Stoffer International Students Scholarship and Scholarship for High Achieving Students in Career Transition, Fort Hays State University, USA. So has been a legal advisor and practicing lawyer since 1991, and he has been advising, drafting, and conducting court cases for many individuals, companies, firms, banks, government and non-government organizations, public sector organizations, universities. To name a few, his client list includes Shivaji University, located at Kolhapur, Central University of Rajasthan, the Ratnakar Bank Limited, Varna Cooperative Bank Limited, Maharashtra State Board of Secondary and High Secondary Education, insurance companies, Ghadge Patil Group of Industries, Shaw Wallace and Company, Central Bureau of Investigation, etc. Sir has also been a founder and coordinator, postgraduate department of law at Shivaji University. He has guided many PhD students in the field of law, and he has been an honorary lecturer in law at various institutions in India since 1991. Sir has published many articles in Marathi and English language in several newspapers, law college magazines, law journals, conferences and seminars, and his articles are spread over to different law related subjects like fundamental rights, electoral law, right to primary education, banking law, etc., to name a few. Sir has many other achievements to his credit. To name a few, he has been a life member of Indian Red Cross Society, Indian Law Institute, New Delhi. He was selected as Best Youth for the district by JC's Club of Kolhapur from 1991 to 1992. He has been a recipient of Rotary International Fellowship to study at Fort Hays State University. He was a president and social chairperson of the International Students Union. He was an ex-member at Senate Law Faculty and Students Council at Shivaji University. He was at International Service Director, Rotary Club of Kolhapur, Midtown, from 1993 to 1994, and so has participated in many moot court competitions, legal aid clinics, Model United Nations and allocation competitions, and has won several prizes in these competitions. So I welcome you, sir, to this virtual gathering and request you to continue to start with your presentation. Over to you, sir.
Thank you, Nikita ma'am. Sir, we can have the screen sharing and then you can start. Can we have sir's PPT? Gauri?
Yes, I think.
Yes, sir. Sir, is it comfortable?
Yeah.
Yes, sir, we can start.
Yeah, I think she has, no, she has to start from the beginning, the first slide.
So this
Yeah.
is, yeah.
Okay, let me just begin and then I think she can put the slides as I go on.
Yes, sir.
Yeah.
Yes, sir.
Can I start?
Yes. Yes, sir,
Yes,
for sure.
yes. Let this be there. You can wait, you can go to the first slide, please. Can she hear me?
Yes, sir, she'll be able to hear you.
Okay, no. Yes, she has to go to the first slide. The title slide. Can she hear me?
Yes, sir, she can hear you. Gauri, go to the first slide.
Navigating the complexities of the consumer laws in India. Yeah, I think she can just wait. And then as I go on, I think I'll tell her to put the slides.
Yes, sir. Gauri, put the first slide only, with the title slide. One second, sir. There may be a technical glitch. Yeah, I'll just get back.
It's visible now.
Yeah.
We can start with the presentation, I guess.
Yes, sir, we can start the issue sort.
Okay. All right. Good evening. Principal Dr. Shweta Wadhwani of Jayantilal H. Patel Law College. Somebody who has been taking great efforts to organize this webinar. Professor Dr. Viral Dave. Professor Nikita Patil, who just introduced me so well that increases my blood pressure, and of course my friend, somebody who is very well known amongst the practitioners of consumer law in this state and even in the country, my friend Advocate Anand Patwar. I don't know if he's in, but he's responsible for getting me here. Okay. The topic or the subject of today's webinar, as we can see in the first slide, is navigating the complexities of the consumer laws in India. Now, we'll just take a few moments to first understand this topic and what will be my role while dealing with this topic, because tomorrow you are again going to have Advocate Patwardhan talking to you. We have divided the topic amongst us in of course, consultation with Professor Dr. Viral Dave in two parts. Today, you will hear more about the history of consumerism in world, more particularly in India, number one. Number two, how the Consumer Protection Act, the old Consumer Protection Act 1986, came into being. Number three, the major provisions, salient features of 1986 Act. Number four, some landmark judgments which were given under 1986 Act. And finally, what were some lacunas in the Act which led to what you have today as Consumer Protection Act 2019. So that will be the method in which I will be dealing with the topic. Okay. So to start with, can we have the next slide so that you get the perspective of the background and historical perspective? Can we have the next slide, please? Yes. See, and of course, there's one more thing which I would like to add is I have kept in mind that I am dealing mainly with the students. Of course, in law, everyone is a student, even if you have completed 30 years, 40 years in this field as a lawyer or a judge, you still remain a student because law means learning every day. But I have thought more about this topic more from the point of view of students, considering that this is a law college and most of you will be students. Okay. See, there's a very famous quote by a great judge which this country had, a very scholar judge, Justice Krishna Iyer. He has said consumerism is humanism and humanism is consumerism. Right? That tells you that consumerism is very closely related to human beings, to human rights and humanity. Okay? I will elaborate a little more on this as I go on. On the western side of this, John F. Kennedy, who was the president of the United States, has said that consumer by definition include us all. They are the largest economic group affecting and affected by almost every public and private economic decision. Yet, now this is important, yet they are only important group whose views are not often heard. So, John F. Kennedy said that though they are very, very important group, they are affected by all the private and public decisions, their views are not often heard, was what he said when he was the president. Of course, how things have changed, we will see.
Santosh
Can we
sir,
have the next slide, please?
Santosh sir?
Can we have the next slide?
Yeah.
Sir, your voice is breaking. There is a bandwidth issue. Hello? Santosh sir?
हेलो संतोष सर
लेफ्ट हो गए शायद से मैम।
हेलो
मैं कॉल करती हूँ।
हाँ हाँ
There is a technical glitch as far as Sir's internet connection is concerned. He'll be joining us in 2 minutes. Participants are requested to kindly bear. Sir is joining in 2 minutes as there is some technical glitch on his part. His bandwidth is not working properly. He'll be back with us in 2 minutes. Gauri, we can have the slides back.
Unmute me काय जाना. Yeah, can everybody hear me?
Yes, sir.
Yes, sir, we can hear you.
Am I in again?
Yes.
Can you hear me?
Yes, sir. Yes,
We
sir.
can hear you.
Sound. Yeah. Can you hear me?
Yes, sir. We
Yes,
can hear. Yes.
Yes, sir.
Some technical problem. Okay.
Yes.
I will continue. Everyone can hear me, right, and see me.
Yes, sir. Yes,
Yes,
sir.
sir.
We can see you.
I can see Advocate Anand Patwardhan. Welcome.
Yeah.
All right. Now, coming from Justice Krishna Iyer and then Kennedy, we all know what Mahatma Gandhi has said. A customer is the most important visitor in our premises. He is not dependent on us. We are dependent on him. He is not an interruption of our work. He is the purpose of it. He is not an outsider of our business. He is part of it. We are not doing him a favor by serving him. He is doing us a favor by giving us the opportunity to do so. So the importance that Mahatma Gandhi gave to a consumer can be seen here. Well, today, of course, we are now in leaving at least part of our lives, all of us, in a virtual way. This webinar is an example of it. Today, or just before this also, every one of us is a consumer from birth to death, and from moment you get up in the morning till you sleep. In fact, I today
Sir, your voice is
we all have to take
screeching.
is not
Your voice is screeching.
to buy, but what not to buy. There is so much going around on the net, or there is so much of advertisement and salesmanship and marketing which is going on. The
Gauri, can you play some soft music while his technical glitch gets solved? If possible, you try. Yeah.
Yes, am I in again?
Yes, sir. Yes, sir. You are audible.
I don't know what's happening. Or anyway, we will continue. Can we have the
Yes.
next slide?
Yes, sir.
Yeah. Okay. Now, the basic question which we all have to answer and think about is why laws? Okay. Okay. My simple answer to it is twofold. See, laws are there to deal with a mischief in the society. There is some mischief in the society, and the laws wish to deal with those mischiefs or mischief. And secondly, it is also there to regulate human conduct. Okay. The sociological theory would tell you, as Justice Holmes says, laws are felt necessities of time. As time changes, laws have to change, and laws have to keep pace with the times. If there is gap between the two, it is bad for both. Okay. So let us keep this in mind and see how Consumer Protection Act 1986 came into existence. Can we just have next slide? Right. Can everybody hear me now? Hear and see me?
Yes, sir.
Yes, sir. Yes, sir.
Yes, sir. We can hear you.
I will start from the ancient times. Okay. You would agree with me that consumerism came in only with advent of trade and commerce. In a pre-civilized world where there was no trade and commerce, when life was very simple, your human needs were limited to food, shelter, clothing, no trade, there was no question of consumerism. But as we invented money, as we started barter, and then as we started trade and commerce, consumerism came in. There are references of consumerism in Vedic period. There are references of consumerism in Kautilya's Arthashastra. Kautilya's Arthashastra mentions consumer protection against exploitation of consumers. Even in Manusmriti, selling false good, the reference is found that selling false good and unclean meat would result in punishment of maiming, is what Manusmriti says. During Muslim rule, there is a reference of Sultan Aluddin Khalji, who introduced price control measures during those times. So if you think about it, actually, in ancient India, there was some form or the other of consumerism already there. Let us now come in recent times. Let's come into the colonial region. Can we have the next slide, please? Well, as we all know, colonial region, which is thought to be 1765 to 1947 in India, as we all know, British came to India not at all with a view to develop or regulate India for the Indians. Their ideas were totally different. Their ideas were first commercial and then, of course, political. That therefore affected consumer protection. They did not at all think of consumer protection in India when they were there. But there, in 1932 to 35, there was a development in UK, which is, I think, very, very important. And that, I would say, is a very first, and I'm sure all of those who are students of law, I think you, many of you must have studied this case. I take this as a
So kindly unmute yourself.
yeah, I have.
Yeah.
Can you hear me? Yeah.
Yes, sir. Yes.
Yeah. So the first landmark judgment, okay, which deals with law of torts and it deals with consumer protection, is none other than Donoghy versus Stevenson. A very important case. I don't know if it's possible for us to play the video for, it's a 2-3 minute video. Can we have that video so that, you know,
Yes.
students can see the video and then
Yes, sir. Yes, sir.
yeah, okay, great.
In August of 1928, May Donoghue and a friend decided to visit the Well Meadow Cafe in Paisley for a pear and ice, and in the case of May Donoghue, an ice cream and a bottle of ginger beer.
It has human interest in a very stark way. The two ladies going to the cafe and buying ginger beer.
Everything was paid for by May Donoghue's friend.
Ladies, what would you like?
Can I have a pear?
Now, the act of buying a bottle of ginger beer for a friend would not be unusual now, and it wasn't then. It was a transaction that occurred hundreds of times each day in countless cafes across the country.
It appeals to people of all ages, of all interests, and of all levels.
An ice cream for you, is it?
But when her friend bought May Donoghue that bottle of ginger beer, the transaction and its aftermath formed the basis of one of the most celebrated and important Scottish cases in world legal history.
Thank you.
When you have the combination of important precedent and an interesting story, it undoubtedly captures the imagination of lawyers.
For in her Stevenson manufactured bottle of ginger beer, May Donoghue didn't just get ginger beer. She discovered something else as well.
It's got, you know, Paisley, a cafe, a friend, ice cream, ginger beer, and a decomposed snail. It's just kind of perfect.
The decisions of courts in cases such as Donoghue against Stevenson are hugely important and have a significant impact on the development of the law, and as such need to be recorded. They are recorded in volumes of law reports.
Law reporting really dates from the 16th century, when judges started to keep records of cases decided in the Court of Session. Through the 17th century, judicial collections known as practics were made. And some judges' collections were printed. The first of all were those of Lord Stair. In 1693, there is the great innovation. For the first time, people can attend the inner house when the judges give their opinions on the case. Before that, it had always been done in secret. And from the 1690s onwards, the Faculty of Advocates becomes very keen to collect decisions of the court. In the later 18th century, Scots lawyers come to value precedent. They start to develop the idea that through the argument between the lawyers, legal points are well worked out. And so the lawyers came to see judicial decision-making as an important way of identifying the principles that they started to think were inherent in the law. Then linked to that were reforms in the Scottish court structures in the early 19th century. And the Scottish courts moved away from the collegiate nature of the bench, with a larger bench deciding, to what we would now see as a first instance and second instance structure in the Court of Session. And this, of course, made it precedent clearer. And of course, it made, for the opinions of the judges, more significant, because you would have one judge focusing on a point, and you could have what, by say the 1830s, the Scots were starting to call the ratio decidendi, the principle which had been decided by an individual case.
The court in Edinburgh was making decisions which was very important. It was establishing principles of law, elucidating principles of law, and that information about what it was doing, what its decisions were making, had to get out there to the general public, had to get out there to the lawyers.
faculty of advocates was interested in getting a collection of reports for the use by the advocates in the court in the early 19th century.
And the way to do that was to have reports of the decisions which were publicly available and could be used by lawyers in advising their clients and by the general public in knowing what the law is. Session cases have been around for quite a long time. They first formally started in 1821. There are 3 divisions within it: the High Court of Justiciary, and the reports from the High Court of Justiciary, which is the Supreme Criminal Court in Scotland. Then there are the decisions of the Court of Session, which is the Supreme Civil Court within Scotland. And then we also have the decisions of the United Kingdom Supreme Court in Scottish matters.
The practice in Scotland of detaining persons for up to 6 hours.
For nearly 200 years, session cases have provided an authoritative record of the most important case law of Scotland.
In essence, they're the most significant Scots law report that we've all grown up with since we were in law school, so we're familiar with it, and we obviously probably go to it first. If there's a session case report, you would use it first because it's the authoritative one.
Okay, can we go to the colonial regime slide, please? Can we go to the colonial regime slide, please?
Yes, sir. Yes, sir.
Yeah, right. Okay. If you have watched it carefully, the case is called as a snail in the bottle case. Okay. It, for the first time, established civil law tort of negligence. Now, see the facts. Miss Donoghue was given a bottle of ginger beer purchased by a friend. Now, these facts are important. She goes with a friend to a restaurant, to a bar, and they together are there, and her friend buys beer for her, ginger beer. Well, unlike in India, we buy tea, there they buy beer, don't worry. Now, Miss Donoghue consumed most of its contents, but later became aware of snail in the bottle. Okay. She later fell ill with gastroenteritis. Okay. And now she goes to court and sues the manufacturer of the beer, seeking £500 damages for the effect it had on her health, physical as well as mental. Okay. Now the defense with the manufacturer's take is basically this, that they have not sold the bottle to Donoghue, or Donoghue has not paid any consideration, and she's not their customer. There was no precedent at that time as to how to deal with this case. And the matter went up to House of Lords, and Lord Atkinson, for the first time, laid down this precedent where 3 things have been established. 1, that there is a basic duty of care to the consumers, okay, which all manufacturers have. 2, therefore, consequently, they are also responsible for injury due to negligence. And 3rd, very important, and I think Advocate Patwardhan will take you there tomorrow, is it established the law of product liability of the manufacturer even against third party, which means though Donoghue had not purchased the beer, her friend had purchased. It was her permissive and friendly gesture due to which she drank the beer, in which case she also has a right of suing the manufacturer under product liability. So it opened the doors of law of torts of negligence. And that is how, you see, though in colonial regime, India did not make much strides in consumerism. There in UK, and this is of course a Scottish case, great strides were made due to this case. Now we'll go to enactment of Consumer Protection Act, period just before independence or just after independence, before Consumer Protection Act comes in. Can we have the next slide, please? See, post-independence period up to enactment of Consumer Protection Act 1986, okay, we adopted socialistic pattern of society. If you see in the Constitution of India, there is a chapter on directive principles of state policy. And Article 38 says that the state should secure social order for promotion of welfare of the people. So, we adopted socialistic pattern of society. At the same time, our greatest need after independence was industrialization. Now, industrialization naturally led to exploitation of consumers. You remember the times when the only cars we knew were Fiat and Ambassador. Then for many years, we at least had Maruti, a great, break-in in the market. And after that, now you see there is so much of choice that, everything had changed. So initially, there were monopolies, restrictive trade practices. But then, because there was a lot of exploitation, there was no spatial law which was there to protect the consumers. Though, one could go to civil courts under law of torts, as we saw. There was no spatial law. There was no law which gave good access to consumers for redressal of their grievances. There were many organizations which came up in this country. One which I would name here is Akhil Bharatiya Gram Panchayat, and one Mr. Bindu Madhav Joshi. They made a lot of efforts, and all of this resulted into enactment of the Consumer Protection Act 1986. Can we have the next slide, please? Right. Now, see, just before that, General Assembly of the United Nations adopted guidelines for consumer protection on 9th April 1995. Not before, of course. I think it's 1985, it should be. So there was an international pressure also as far as consumer protection is concerned. And we have the Consumer Protection Act in 1986. Now, keep in mind that this act is amended twice. I will not go into, in the limited time, why it was amended, what were the amendments, because I will deal with all the act together as it stood just prior to the repealing. It was amended once in 1993 and 2002. The basis of this act is, first, as you can see, to give the consumers a cheap, speedy, easy, and informal remedy. Now, let us understand each of these words and how the act aimed at giving this remedy. Cheap. See, if you want to go to a civil court to file a case under law of torts, or for that matter under any other law, you have to pay a stamp duty. You have to also engage a good lawyer like Advocate Anand Patwardhan or some such as that. Of course, all of that results into greater cost. Now, under Consumer Protection Act, initially, consumer complaints, as far as I remember, were all free of charge. Later on, some charge has come, but that is also very, very reasonable. And even today, under the 2019 Act, Mr. Patwardhan will make it clear, the stamp duty or the payment that one has to pay for the complaint is very, very negligible as compared to our civil courts. So it's a cheap remedy. So ultimate consumer, a common consumer, will be able to, invoke the jurisdiction of consumer forum. It is also supposed to be very speedy. That says that every complaint should be disposed of within 90 days. Thereafter, even the appeal periods are of very limited duration. And therefore, it aims at speedy and summary disposal of cases. You don't need. Third is easy. Why easy? Actually, if you want to go to a civil court again, you have to follow all the technicalities of pleading. Your plaint has to be in a particular fashion. There are rules of Code of Civil Procedure which you must follow while drafting and presenting a plaint. All of this does not apply to consumer complaint. You can be very, very simple, brief. You can only introduce yourself. You can introduce the opponent, how you came in contact with each other, what is it that you have bought, either the goods or services, and what is your experience? Why are you complaining? What is your problem with the goods and services? And what is it that you want from the forum? Okay. So very simple, no technical, no formal, rules of pleadings need be followed. So it's an easy remedy. You don't really need lawyers for it. One can draft a complaint oneself and file it in the consumer forum. And even the consumer fora or consumer forum, consumer complaints redressal mechanism is thought to be a quasi-judicial authority, not strictly judicial, not strictly non-judicial. So it's an informal remedy. The forums normally do not at all record evidence the way it is recorded in civil courts. They take complaint, they take replies, they take documents, they take affidavits. It's a summary procedure and they give judgment. So, it was a major stride. It was one of the best pieces of legislation with very few sections. So it kind of gave a great breakthrough from other laws, one of the best pieces of legislation we ever had in this country. Cheap, speedy, easy, and informal remedy. Of course, as we go on, we'll also see, as we say in India, many a times, we are very good at passing the laws, but sometimes very bad at implementing them. So we'll see what happens thereafter. Let us go to some other important provisions of the Act. Can we have the next slide, please? Yeah. Now, I'm purposely bringing in some provisions which then will be, if there is any change in those provisions in the 2019 Act, I'm sure Advocate Patwardhan will bring in those changes. The first important provision which I would like to point out, because there's a change in this now, which you will know tomorrow, is jurisdiction of the forum is where the opposite party resides or carries on business or cause of action arises. Which means if you are buying something where you are, you can file a complaint at the place where you are only if your opposite party also resides or carries on business where you are. But let's say you are in Kandivali and you buy something from somebody who is not in Kandivali, who let's say is in Baroda, then you may have to go to Baroda to file your complaint because your opposite party is there or is carrying on business there. But there is one one other factor which can play in where cause of action arises. Though your opposite party may be outside, if you can show that the defect which has occurred in the goods or deficiency which you have suffered in the service is where you are, then the place where you are can get jurisdiction. So there was that latitude which was there, but the rule was that opposite party or cause of action. So one had to really show how the cause of action came to the place where you are. Now this rule had changed. I will not go to the change. Mr. Advocate Patwardhan will elaborate on the change tomorrow. Then the limitation for going to the consumer forum was 2 years from the date of cause of action, which means from the date you suffered the deficiency or the defect, you had to go to the forum within 2 years. Okay. See, in civil courts, normally this limitation is 3 years. Here it is 2 years. Now, interesting composition of the forum. See, this is probably unique composition for the first time in any legislation. Now, you have NGT where similar composition is there. There will be one president at the district. I will come to that district, state or national commission, who will be with legal background. Okay. Normally, in district, person who is eligible to be a district judge, state eligible to be a high court judge, and national eligible to be a Supreme Court judge. So president will always be a person with legal background. Now, interestingly, 2 other members, of whom one shall compulsorily be a woman. Okay. And what is it that it is required? It is required that they should have knowledge and experience of at least 10 years relating to economics, law, commerce, accountancy, industry, public affairs, or administration. Okay. Now, this is interesting provision. They wanted somebody who understands, other than somebody who has legal knowledge, understands the actual business practices, to come in as member and they become a panel, and the purpose obviously was that there will have to be a view which is coming from a social perspective, a business perspective, a consumer perspective, which will then result in consumer justice, was what the view was when the this type of arrangement was made. We will now go to the next slide, and I'll show you how the forums were divided. District forum, and what is the jurisdiction? Now, district forum were given jurisdiction after amendment. Initially, it was less, up to 20 lakhs. So the amount that you are claiming or the relief that you are claiming, if it is valued up to 20 lakhs, one had to go to district forum. If the value was between 20 lakhs to 1 crore, one had to go to state commission, which is in Mumbai with their branches at Nagpur and Aurangabad, and they also now are sitting at various places in the state. And national commission, which is at Delhi, 1 crore and above. Appeals from district forum would go to state commission, from state to national commission, and national to Supreme Court. And Supreme Court, of course, as we know, is the final court. Now, I would like to take a pause here. In fact, one of the things which was being said is, if you have somebody who is capable to be a district judge sitting on the forum, then you see a similar type of dispute which goes to a civil court, you have a civil judge who is given unlimited jurisdiction. There is no ceiling on the jurisdiction of civil judge senior division. He can entertain any suit of unlimited value. Now, therefore, the logic behind keeping these ceilings to district, state, national commission was being criticized. And now I think there is a change. And now there's a change in this, where I think Advocate Patwardhan will tell you what is the change in this particular pecuniary jurisdiction of district, state, and national commission. Can we have the next slide, please? Okay. Now I will go to crucial definitions in the Act, and that I think will open before you what that Act really was doing. First is, what is a complaint under this Act? Now, complaint means any allegation in writing made by a complainant. Okay. Allegation in writing made by a complainant relating to what? An unfair trade practice. Now, the term unfair trade practice is defined elsewhere in the Act, and it's a very wide definition, and it is not a complete definition. One can include even practices which are not included in that definition if one finds out that one feels that it's an unfair trade practice. Restrictive trade practice, defective goods, any defect in goods, deficiency in service, charging of excess price, selling of hazardous goods, and marketing of hazardous services. So one could make a complaint in respect of any of this: unfair trade practice, restrictive trade practice, defective goods, deficiency in service, charging of excess price, selling, it has to be selling of hazardous goods, and marketing of hazardous services. Now, out of these, our experience is that complaints came in more under two categories: defective goods and deficiency in service. In fact, there was a great scope for filing complaints under unfair trade practices, but somehow it was not used as much as it could have been used. So our experience is defective goods and deficiency in service is what was mostly used by consumers, because those are very obvious, and that's what we face day to day. Can we have the next slide, please? Okay. Next important definition is that of complainant. This is also a very important definition. Who can be a complainant? Who can go to the consumer forum? Okay. Number one, obviously a consumer. Two, they have allowed any voluntary consumer association registered under the Companies Act or under any other law for the time being in force. So voluntary consumer associations can file complaints for consumer redressal in the consumer forum. Interestingly, third, central government or state government can also be complainants. I haven't in my practice seen central government or state government coming to the forum on behalf of consumers for consumer redressal. That definition is there. It has remained as it is. Next, which is also a very, very powerful definition, but again not used. One or more consumers, where there are numerous consumers having the same interest. Now this in US is called class action. It's a very powerful weapon used in US, where there are numerous consumers and they have the same interest. One of them can go to the consumer forum and represent the class. To give you an example, many a times you see we go in the market, or to take a concrete example, suppose you are on a railway station and you buy a bottle of water. Okay, there you are made to pay 25 rupees when the MRP on the bottle says 12 rupees. Okay, now and you feel that there is no reason why you are being charged more. Or let's say you buy a toothpaste from the market and you pay the price and you find that the toothpaste, though it says it's 200 grams, actually the weight, if you really weigh it is only 150 grams. So you are cheated with 50 grams. Now for these small things of 10, 12 rupees and 50 grams, normally you will ignore. You won't complain. You won't keep any receipt. You won't do anything. You won't have the time, money and energy to go to consumer forum for this injustice. Now, this is where these types of class actions can come in. Suppose somebody who has suffered like this goes to a consumer forum and files a complaint and says that, look here, I have bought this toothpaste and it is weighing less, and take my complaint and convert it into a class action. Okay, then you will understand that if it's only your individual complaint against the manufacturer or the trader and the trader, they will say, okay, whatever happens, 200 grams ka paisa jitna dena hai, de do, some compensation de do and get out of it. But the moment you say convert this into a class action, the consumer forum will allow you to publish it in the newspaper, in the media, and they will invite all those who are similarly situated, all those who have similarly suffered or cheated, to come in the complaint. And once that happens, you know that the manufacturer or trader, howsoever big the trader or manufacturer be, will have to surrender. And then, this type of great unfair trade practice can come to a great halt. And then you can, reap compensation of crores of rupees for a number of consumers. But somehow in my practice, I have rarely seen this class action method being used by consumers, or for that matter, anybody in the definition. And last, it also says in case of death, legal heirs or representatives or people who make complaint, okay, are also of people who make complaint are also can also be complainants. So important is for us mainly consumer and voluntary consumer associations and class actions. Can we have the next definition, please? Next slide. Yes, this is slightly bigger definition, but I think we need to understand, because there was a lot of debate about this definition. A lot of rulings came in, and I will, when I go to some landmark rulings, I will also show those rulings. But it's important for us to understand who can be a consumer under the Act. Now, if you read the definition, let's read it together. It says, who is a consumer? Any person who buys any goods. It has to be buys any goods for a consideration. So first important requirement is there must be consideration. Law of contract, offer, acceptance, consideration. There has to be money which must flow in if you want to become consumer. But it can be paid, which has been paid, or promised, or partly paid and partly promised. So it need not be entirely paid. It can even be promised. It can be partly paid, partly promised. It can be paid in installments, but there has to be that promise to pay consideration. second important aspect, or under any system of deferred payment. Now, third important aspect of the definition, very important, and includes any user of such goods other than the person who buys such goods for consideration paid or promised or partly paid or partly promised. This is also very important. Any user of the goods, it need not be the consumer. So Donogi was a user of goods. She is allowed under our act to go to consumer forum, provided she has the approval and she is using it with the approval and consent of the consumer. So user of such goods other than the person who buys such goods for consideration paid or promised or partly paid or partly promised or under any system of development, such use is made with the approval of such person. So it is made with the approval of such person. Now I will take a pause here. Again, I didn't see people other than consumers going to the consumer forum and saying that I was allowed the use, I am the beneficiary of the service or the goods, and therefore I should have access. Normally, that was not found. Now, there is an exclusion clause in this definition, which says it does not include a person who obtains such goods for resale or for any commercial purpose. Okay. Now, this is important. The consumer definition excludes from its people who bought goods for resale for any commercial purpose. So if you are buying it for commercial purpose, if you are buying goods for resale, you are not a consumer. We will come to exclusion or exception to this exception little later. Definition of service is similar. Again, hires or avails of. Hires or avails of. You need not hire, you can even avail of any service for a consideration which has been paid or promised or partly paid and partly promised or under any system of deferred payment and includes any beneficiary of such service other than the person who hires or avails of the services for consideration paid or promised or partly paid and partly promised or under any system of deferred payment when such services are availed of with the approval of the first mentioned person. So again, similar definition, goods, services. Again, there is exclusion here, but that does not include. Now, this exclusion came later in the Act, later by way of amendment in the Act, does not include a person who avails of such services for any commercial purpose. So again, you see that the definition excludes the definition of consumer under the Act excludes use of goods or use of services for commercial purpose. Now there is an exception to this exception, and that exception we haven't put it on slide, but I will just read it for you, which is by way of explanation. It says commercial purpose does not include use by a person of goods bought and used by him and services availed by him exclusively for the purpose of earning his livelihood by means of self-employment. Now see, let us again go back to the entire thing. Consumer includes any person who buys goods or avails of services. Okay, but it excludes those who buy goods or avail of or hire services for resale or commercial purposes. But again, if you are buying goods even for commercial purpose or hiring of services even for commercial purpose, for the purpose of earning your livelihood by means of self-employment, small ventures, small traders, small retailers, small businessmen who buy goods as a means of self-employment, they are dependent for their own livelihood for that particular small shop, small retail venture, then they can still come in and become consumers. It's an important thing. Now, therefore, there was a lot of litigation and debate on this definition. I will show you some landmark judgments which will clarify to you how our courts have dealt with this definition of consumer. Can we see the next slide, please? It also defines goods. Goods means goods as defined in the Sale of Goods Act 1930, which would be movable goods. But then even for immovable goods, the Act will be applicable because in respect of immovable goods, there will be service which will come in as is held in rulings, which I will come to. Next slide, please. Okay. service means service of any description which is made available to potential users and includes, but not limited to, the provision of facilities in connection with. Now, let's read all the services which have come in. Banking, financing, insurance, transport, processing, supply of electrical or other agency, board or lodging or both, housing construction, entertainment, amusement, or the purveying of news or other information, but does not include, now again here they have made it clear, rendering of any service free of charge or under a contract of personal service. Okay. So again, this definition is not all inclusive. This, as it says, it includes but is not limited to these particular categories. So there can be services which are not included here but can come in. Now the immediate example I will have to give to you is medical profession. Okay, see here you will find that medical profession, or for that matter any professions, are not used, are not included. But later on, by the judgment of the Supreme Court in VP Shanta versus Indian Medical Association, the act was made applicable to medical professionals and for that matter all professionals. So the definition of service can be seen in this manner. Okay. Now let us, the act really gave, and there were many people who otherwise would never have come to civil court came to consumer forum. They filed their complaints. A lot of judgments came in. It did have an impact on the traders, manufacturers, in the sense that they then could not, carry out exploitation of consumers in terms of deficiency of service, defect of goods, unfair trade practices, and it did have an impact on them. Okay, but though it had that positive impact, as we say, of easy, informal, cheap remedy, okay, it did have some problems, and I will now go to some problems of the act, and then we'll see the landmark judgments in the act. Let us see the next slide, please. Well, the world changed, as you know, and more particularly in last few years. You have seen that there is great growth of e-commerce, e-platforms, and more so because of COVID. Now all malls are closed, big places are closed, and even if they are open, now you are scared to go out and buy anything, and therefore you prefer going on e-platforms and ordering Amazon, Flipkart, Snapchat, and whatnot, the goods and services that you need. Now, it was debatable, okay, whether the old act applied to e-commerce, e-platforms. Though I will make it clear that there are judgments of the National Commission, and even State Commission and even District Forum, where act was made applicable even for these types of e-commerce transactions and e-platforms. There were two problems. One problem was that there was a limit of pecuniary jurisdiction, as we saw, of the district, state, and national commission. Second great problem was that, you see, the jurisdictional aspect of where you buy goods or services, okay, and where the defendant or opponent is, remained as an objection coming from companies like companies which were engaged in e-commerce, because they would obviously be outside many a times where you were. And therefore, though the act applied to e-commerce and e-platforms, it was not able to effectively deal with challenges of e-commerce and e-platforms. That was something which was there, and I think Advocate Patwardhan will take it to the next level and tell you how the new act deals with e-commerce and e-platforms. Secondly, as I said, there was a problem of territorial jurisdiction. One could not, just because where one is, or on the basis that you are at a particular place, go to a consumer forum. You had to convince the forum that the cause of action arose where you are. So that problem of territorial jurisdiction was there. Now, how it is resolved, again, Mr. Patwardhan will take it over. problem of pecuniary jurisdiction, limits of pecuniary jurisdiction, as I pointed out, were there. One major problem we all faced: lot of delay, lot of pendency. There are various reasons. I won't in the limited time go into it. Apathy of government, not providing enough facilities and services. There was deficiency in service on behalf of the government while manning consumer fora, staffing, etc. All of that led to a lot of delay and pendency, and that had a very negative impact on the implementation of that. And one other provision, see, as in the civil court in the year 2002, in the year 1999, there were amendments, and in the Code of Civil Procedure, there was Section 89 was introduced. Then at the same time, there was Arbitration and Conciliation Act 1996, which came in. In the civil courts, alternative dispute resolution mechanism came in. Civil courts, civil judges, lawyers, from top to bottom, started using arbitration, mediation, conciliation, lok adalat as alternatives for litigation. Now, there was no provision, or there is no provision in the 1986 Act about use of any of these alternative dispute resolution mechanisms. My own impression, though there was no provision, mediation can be used anytime, anywhere. But since there was no provision, no awareness, no urge to use it, all the disputes, even simple disputes, went on in the forum for years together, and that was not good for the pendency, for the consumers, or for that matter for the system. And this lacuna was also found out, and now it is trying to be dealt with in the 2019 Act. I think I will not go into it. Advocate Patwardhan will again deal with it tomorrow, I'm sure. Next, can we have the next slide, please? There is no provision. Now, this is important. In the 1986 Act directly relating to misleading advertisements, though there is a provision in unfair trade practice about withdrawal of this advertisement, no particular provision which would entitle the consumer to get compensation for misleading advertisement, though it could fall in the unfair trade practice, no specific provision. And most importantly, and this is where those of you who like Bollywood, who like sports, have to take it with a pinch of salt. Now they have defined endorsers of advertisements. Okay, so all those who endorse advertisements, your celebrities, your Bollywood actors and actresses, your sportsmen, sportswomen, okay, who endorse advertisements, if it is found that those are misleading advertisements, and they have defined what misleading advertisements are in the new Act, they can be held responsible. Okay, I will not go much into it, but there was, I will only point out that under the old Act, there was no specific provision relating to misleading advertisement and its endorsers. Now, and that was found out to be a lacuna, and therefore you will see that, people would come in and advertise anything, okay, fair and lovely, whatnot. In 7 days, you become fair, okay, and whatnot. These advertisements, there could not be any check on them, though they had their own voluntary association. It was not sufficient. Now that was found out to be a lacuna in that. It could not effectively deal with such advertisements. It could not at all reach to the endorsers. See, why endorsers is not that we are against any Bollywood actors, actresses, or sportsmen. See, my saying something and Sachin Tendulkar saying something about sports is going to make a lot of difference in the minds of those who hear it. So, advertisement by somebody who endorsing has a great impact on the viewers, and therefore a duty is also cast on the advertisers, those who endorse the advertisements. Duty should be cast on them to do due diligence and not to go in and advertise anything, even if they know, they're sure that it's misleading, it's false. Okay, Of course, Advocate Patwardhan, I'm sure, will deal with this. Another very important lacuna which was there in the new act, in the old act, there was no specific provision relating to unfair contracts. Now, you will ask me, what are unfair contracts? See, in practice, you find that many a times, okay, in commercial world, if there is somebody who is if there are two parties and one party is in a dominant position, let's say bank and customer, okay, you will find that if you want a loan, the bank will tell you to sign on dotted lines on 10 documents, register 10 documents, and then only they will reimburse. Okay, websites, platforms. If you want to buy anything, you will have to click in and say yes to all that they say. If you don't, then you cannot buy the goods or services which are marketed by that particular website. See, here, they being in a dominant position, they dictate their terms. Okay, and many a times you find that later on, when there is some problem, those contracts are one-sided. Those are written in a very one-sided fashion. Okay, and initially also, if you try to tell them that change this clause, change this wording, I have often heard this answer from those people. No, it is there in our system, we cannot change it. For example, in any bank, you go and tell them that, well, this document is there, but there are some clauses which are absolutely one-sided, make them neutral. They will say, no, we can't, it's there in the system. So systems have become more important than human beings, and that leads to unfair contracts. Now, under the old act, there is a very good judgment of Supreme Court in Urban Land versus Govind and Raghavan. It's a judgment given on 2nd April 2019 by Justice Indu Malhotra. You will also find that often there are contracts between builders and customers which are one-sided. Okay, for example, there will always be a clause. If there is a default on behalf of consumer, okay, he has to pay interest at 18%. But if there is a default on behalf of the builder, he has to pay interest only 9%. See, simple thing. Many one-sided clauses in a contract like this. Now, a similar contract went up to Supreme Court, and the Supreme Court struck down this contract as being unfair. So this concept was there. It was termed as unfair trade practice under the old act, but there was no specific provision relating to unfair contracts. There is no specific provision relating to unfair contract under the old act. So that was also thought to be an lacuna, because we were experiencing all these things. We were experiencing misleading advertisements. We were experiencing unfair contracts. We were experiencing all these lacunas, and the 86 Act was not able to effectively, completely deal with it because there were no specific and direct provisions. Next provision, and this was also a great lacuna, there was no power of review to the district forum. It should be district forum. And therefore, oftentimes, simple mistakes by the district forum, or there was a limit for filing of, a time limit for filing of written statements, says of the opposite party. If those limits were extended, there was no power to the district forum to review its own orders. See, all courts, all tribunals, they are all human beings, and to err is human. And therefore, there is every possibility that mistakes would be committed. But if there is no power of review, which is there in all civil courts, most of the other tribunals, then for simple mistakes, one had to go to higher courts like State Commission, National Commission, Supreme Court, etc., which led to unnecessary litigation. And that was thought to be another lacuna under the old act. Now, I think one last and a major lacuna in the act, and this is where you see there is a lacuna in our whole system, whether you talk of civil courts or consumer forum, is okay, you get a judgment, you get an order in your favor, where do you go to execute it? If the other side does not obey, what do you do? you have to again go to the forum and file a petition. Under the 1986 Act, you had two alternatives. One, if it's an order for recovery of amount, the consumer forum would relegate you to the collector's machinery, and the collector then can recover that amount as land revenue. Now let me take a pause here. Relegating you to the collector for collection as a land revenue, you know how busy the collector's machinery is. And it was found out to be absolutely a hopeless method of recovery. Collectors have no time, they have no force, in the sense, no force of the consumers, because consumers are unorganized people. They don't have that vote bank, and therefore hardly anything was done through collectors' machinery for recovery, and recoveries was a big problem under the old Act. The second alternative which the consumers had under the old Act was otherwise you filed a complaint in the otherwise you filed an execution for punishment, okay, of the opponent, that the opponent has failed, purposely failed, omitted to obey the order of the forum, and that was made a punishable offense with fine and imprisonment. Now see, if you make anybody answerable to criminal law, you have to follow all the methods of criminal procedure code. So consumer forum were given all the powers of a criminal court, and they had to try this as a criminal case. Okay. Now that led again to a lot of delay, and execution therefore under the old Act was hampered. It wasn't effective. Now Advocate Patwardhan will tell you whether under the new Act, what is the provision, what have they made, and whether it will be an effective execution in the under the new Act. What is the change will be clear to you tomorrow. I will not go into it. So execution was a great problem. How far they have solved it is what remains to be seen under the old Act. Okay. Now I think I will go to, I have 15 more minutes. I will go to landmark judgments under that. Professor Dave, are we audible? Is everyone with me?
Yes, sir. Yes, sir. You're audible. Quite audible. Yes, sir.
Right. The first landmark judgment, which is given by Supreme Court in 1995, and it's Lakshmi Engineering Works. We will just see the small facts of this case. Lakshmi Engineering is a proprietary concern. Mind you, it's a proprietary concern. It's a small-scale industry having obtained financial assistance from various sources. Though it's a proprietary concern, it's an industry. It has obtained financial assistance. It placed an order from the respondent for supply of a machine, okay, which is called PSG 450 CNC Universal Center Machine. It found out that there is deficiency in service and defect in the machine, and therefore it went to the consumer forum. And the question before the forum was whether Lakshmi Engineering Works could become a consumer. Now, if you recollect the definition of consumer, it says if you have bought goods or services for commercial purpose, you don't become a consumer. For resale, you don't become a consumer. Exception, if it's by way of means of self-employment as a means of your livelihood, you can still become a consumer. Here, therefore, in fact of every case, here the Supreme Court laid down that nature and character of machine and material on record shows that the machinery was not bought by the complainant for the purpose of earning his livelihood by means of self-employment, and therefore Lakshmi Engineering Works was held not to be a consumer. Second judgment, can we have the next slide, please? Where the test of being a consumer is laid down in Cinco Textile Private Limited, it's National Commission judgment of Justice Irani. Here the facts were: complainant purchased generating sets at the cost of rupees 5,53,000. Generating sets complained to be defective. Held generating sets were purchased for generating electricity in complainant's factory for the purpose of commercial production, and therefore complainant is not a consumer. Test which is laid down, which is followed in Lakshmi Engineering, is person buying goods either for resale or for use in large scale profit activity will not be consumer. So resale or large scale, mind the words large scale profit activity. So the Act aims to apply to ordinary consumers and small ventures who make a living out of it. So it is necessary when you go to a consumer forum, make sure that your client is a real consumer. He is dependent on this business for his livelihood. It's a small venture. Therefore, if it's a big company who buys something, a big company who avails of some service, who's a company which has hired a staff, which has many drivers, etc., they don't become consumers. Act aims to reach out to actual, ordinary, and ultimate consumers. Next slide, please. Another judgment, Consumer Guidance and Research Society versus BPL. Buying a paper copier, okay, a Xerox machine, to enable to earn livelihood by process of self-employment is held to be a consumer. So that's one of the judgments which tell you that small consumers, even if they are using it for resale or commercial purpose as a means of livelihood, they become consumers. Let us go to another landmark judgment. Next slide, please. Now, this is one of the most crucial judgments under the Act, which is Lucknow Development Authority. I'm sorry, this is not spelled properly, versus M.K. Gupta, 1994 Supreme Court. Let us read what is held in this judgment, and it is truly a path-breaking judgment. It says, Consumer Protection Act is a social benefit-oriented legislation. Its provision should be so construed, therefore be construed in favor of consumers. The Consumer Protection Act is made applicable, and this is important, to statutory authorities and local bodies along with private enterprise. Now see, for the first time, the Supreme Court says, don't think that consumer courts or consumer forum or consumer complaints can be filed only against private bodies. It can also be filed against statutory authorities and local bodies. You can become consumers of statutory bodies and local statutory authorities and local bodies. Okay, that's a very landmark judgment. Secondly, here the court also accepted that, well, apart from actual loss, apart from actual compensation for the correction which is there in the goods or in the service, one would also be harassed. So compensation for mental agony, for operation, can also be sought for in the consumer forum. Okay, so three important things in this judgment. One, you can file complaints against statutory authorities and local bodies, provided it's goods bought for consideration, services hired for consideration, not free of charge. Two, second important part is that you can also claim compensation in consumer forum for mental agony and operation, and just not actual correction. So these are very, very landmark two directions which the Supreme Court gave. And here the Supreme Court directed the department to pay the amount to the complainant, but to recover the same. Now, third important, as I said, third very important part of this judgment is that the Supreme Court ordered that Lucknow Development Authority should pay this money out of the funds. But as you know, the funds of the public authority are your and mine funds. They are public funds. So why should you and me suffer? Therefore, it said, now you paid, but make sure you recover it from the person actually who is responsible for such deficiency, which means an inquiry will have to be conducted in the department. It will have to be found out who is responsible for this deficiency, who is responsible for this defect, and that money which the statutory authority has paid will have to be recovered from this particular person who is working with the department. And I think this is a landmark, very landmark, and a path-breaking direction. Unfortunately, again, we don't see that happening in practice. Oftentimes, statutory authorities pay and they don't get into recovery, or since there are no directions being passed of this nature, nobody goes into the recovery from persons who are actually responsible for deficiency or defect. But that judgment will take us a long way, I'm sure. So many activities of banks, supply of electricity, supply of gas are definitely included. Okay. Now, one other judgment, which I have already mentioned. Next slide, please. Indian Medical Association versus VP Shanta. Okay, where as I mentioned, medical profession is included. Now, I will just to make you curious about it. A question is being put now whether medical profession is included under the Consumer Protection Act 2019. I will leave you with that. I'm sure Advocate Patwardhan will answer it. But I have to also tell you why this question is being asked. The question is being asked for two reasons. But let me first explain that in Indian Medical Association, the Supreme Court said, well, we all have this concept that doctors are gods or next to gods. And therefore, how can you bring them in consumer forum? How can we say that we are hiring services? All these concepts traditionally are against holding the doctors in high esteem. But the Supreme Court said, well, it's a service which you are hiring. And if you are hiring a service, if there is consideration, then you become consumer. And it's applicable not only to doctors, all professionals are amenable to Consumer Protection Act. And it is not contract of personal service, it is contract for personal service. Okay. So they were included. Now, when the new act and when the bill was being floated, they had therefore specifically included health services in the bill. When that was included, there was a lot of objection coming from medical community that why are you including it specifically? Don't include it, okay? Otherwise, we will be made target of this act. Now, because of pressures from medical fraternity, in the final bill which is passed in the act, those words are removed. Now you will not find in the definition of service health services, okay? And therefore now the question is being asked whether health services, medical professionals, hospitals are still amenable to the jurisdiction of the Consumer Forum under the 2019 Act. I will not give you an answer. As students, I think you think of your own answers, and I'm sure Advocate Patwardhan tomorrow will answer this question. I will just keep it at that. I don't want to encroach on his part of the whole topic. Okay. So I think I'm pretty much in time. Finally, I would quote Winston Churchill. He says, "Courage is what it takes to stand up and speak. Though I have not stood up, I am on the webinar, but courage is also what it takes to sit down and listen." So I am thankful to all the students, the college, again, Principal Dr. Shweta Wadhwani, Professor Dr. Viral Dave, who took great efforts to get me here, Professor Nikita Patil, and of course, one most important person who brought me here, who is a renowned practitioner of consumer law, my friend Advocate Anand Patwardhan. Thank you very much. I think if there are any questions, I'm open. The forum can be open. Professor Dave, would you take on?
Yes, sir. Thank you so much, sir. It was a very illusory session and very grateful, even though we have been teaching consumer laws, but when you are doing it, it's, again, a refreshing thing, and, so many things come back and so many things like lacunas, how many you took out, so then it helps us to teach the students also. Thank you so much. Now I request Pramila ma'am to take over the question and answer session. Pramila ma'am, over to you.
Yeah, thank you so much, ma'am. And thank you so much, sir, for such a beautiful and informative session. And I think there is only one question. And later on, if any participant is having any question, they can raise their hands and we will unmute them to ask their question. So, sir, we are having one question, that whether this act is applicable to cooperative housing societies as per Lucknow Development Authority case.
Yes, for example, let's say there is a cooperative building society, okay, and you are a consumer, but of course there's a special legislation for this. Maybe I think Advocate Patwardhan can answer this better. Can we get him in here? Is it possible for him to come in?
Yes, sir, of course, sir.
Advocate Patwardhan?
Can he be unmuted?
Yeah.
Yes, ma'am.
Yeah. What about cooperative housing societies? Are they? Can one go under Consumer Act against those societies? Oh, he's not unmuted. Unmute yourself.
Yes, he's unmuted, sir.
Can't hear him.
Yeah, can't hear.
Anand sir, am I audible? Sir, you're not audible.
सर कंप्यूटर का ये कर लीजिए.
Am I audible now?
Yes, now you're
Yes,
audible.
sir. Yes, sir.
Yes. I will give this question to you.
Okay. I think there has been one judgment of Kalavati Housing Cooperative Housing Society, wherein the matter which reached Supreme Court, the issue there was the Cooperative Housing Society itself was had undertaken the construction of that particular building. So one of the consumer who had actually paid to the Cooperative Housing Society to get a flat giving services. But in general, this particular question appears to be whether services rendered by a cooperative society to its member in general can be also an issue under the Consumer Protection Act. Technically, no. There is section 91 under the Cooperative Society Act where all disputes would be between the member and the cooperative society would be before the cooperative court or the assistant registrar as per the Cooperative Act. Nevertheless, when it comes to a situation like a cooperative society which is collecting funds for the purpose of repairs and maintenance of that building, in such situation, if the leakage in the flat of a member continues, then in such situation, the member can proceed against the cooperative housing society as well as the contractor to whom the contract has been given for the purpose of repairs and maintenance or the repairs of that particular society. That is how such kind of disputes can be brought under the Consumer Protection Act. Otherwise, every member is actually contributing to the pro rata his share to the monthly outgoings for the maintenance of the building, and that is why it is not some kind of a consideration that is paid to the society.
Okay.
Otherwise, such situations where there is any additional amount paid, for example, parking, I am paying separately for parking, but I am not being given a parking space. Such situation, yes, he does become a consumer, or in case where the parking space has suddenly been turned into some kind of a rubbish which is not cleaned, that also can be an issue against the cooperative society.
So I think it's very clear. To sum up, for limited purposes, yes, but otherwise there is special legislation called the Cooperative Societies Act which will govern.
Okay, so thank you so much, sir. And sir, one more question is there, whether in the given situation of COVID-19, like hospitals be covered under the act of the charging high bills during COVID pandemic?
Yeah, there is no change in law. Indian Medical Association, BP Shanta still holds the field. So even in COVID-19 situation, Consumer Protection Act is applicable to medical professions. So there's no change in law there. Yeah.
Okay. Thank you so much, sir. And sir, next question is, in the 1986 Act, there was only provision for appeal on orders of National Commission given in its original jurisdiction and not on an appeal from State Commission. Why was that? Has it been maintained similarly in 2019 Act?
So there was a provision of appeal from district to state to national and national to Supreme Court. Yes. Yeah. So in 1986 Act, that provision was there. 2019, I think Advocate Patwardhan will mention it tomorrow, what the provisions are.
Yes, sir. Yes, sir. Thank you so much, sir. I think only this much questions we are having. So I request the participants, if they are having any questions, they can raise their hands and we will unmute them to ask their questions. So I think there is no one who want to ask anything. Yeah, sir. Dr. Devraj sir is there. So I'll ask Devraj sir, you have to unmute yourself and you can ask your question, sir.
Hello, madam. Hello,
Yes,
sir.
sir.
My name is Dr. Devraj.
Hello. Yes.
Am I audible, madam?
Yes, sir. Yes,
Yes,
sir.
you
Very
are.
much.
Hello, am I audible?
Yes,
Yes,
sir.
very much.
Sir, the appeal to Supreme Court
Yes, sir.
from National Commission was not there for orders given on appeal to State Commission. When order was given by National Commission from on appeal on State Commission, second appeal was not available for Supreme Court. That is one. And another question is now in 2019 Act, whether the advocates also have been included, because now the all services have been included in 2019 Act.
Okay. I will take your second question first. Well, Advocate Patwardhan can join me. See, 2019 Act, as I said, specifically health services or doctors are not there. Okay. But irrespective of that, Indian Medical Association and VP Shanta versus VP Shanta still holds the field because the definition of service is the same. Okay. So my view is that irrespective of what happened, that the word was included in the preliminary, in one, probably in one house and brought back in the other house. Ultimate Act does not have these words, doesn't matter. Supreme Court judgment holds the field because the definitions under the old Act and the new Act, so far as it concerns, professionals, is the same. So it would continue to be applicable. In fact,
yes, sir.
Advocate Patwardhan will clarify this more. The new mediation rules which have come under the 2019 Act, specifically medical profession. So there is no doubt about it. Now coming to your question whether lawyers are included, it's a good question you are asking to lawyers. My own view, because of Indian Medical Association, all professionals are included. But to my knowledge, and Advocate Patwardhan can correct me here, there is a matter pending in the Supreme Court about this of, I think it's a matter of one Mr. Gandhi, where a National Commission had held that the Act applies to lawyers, the old Act, but the Supreme Court has probably stayed it and it's pending adjudication before the Supreme Court. That's the last I know. Maybe, Advocate Patwardhan is more...
Yes, sir, it is still pending. But the now question is,
the last word.
Now that the 2019 Act has come, whether it will override a Supreme Court's pending case?
No, because the definitions are the same.
Because that case was under the 86 Act.
Right, but definitions are the same so far as it concerns professionals. Service definition is same. And as long as you are hiring it for consideration, any professionals can come in.
Okay, sir.
So doctors are not excluded. That's my view. There is unnecessary debate being made whether doctors are excluded from the new Act. My own view is no. But I think we'll let Advocate Patwardhan talk about it maybe tomorrow.
No, they are not excluded. Literally, they are not excluded. Thank you, sir. Thank you very much.
Thank you.
Thank you so much, sir. So now we are having our last question of the session, that can a consumer complaint be filed against a bank when the ATM fails to let us withdraw money because of insufficient money in the ATM?
Yes, why not? Provided you make proper parties and target. It may not be the bank's fault. It may be the ATM service provider's fault. So maybe you can make a bank party as well as the service provider of ATM a party. And if it's a deficiency in service, they will be responsible.
Okay, sir. Thank you so much, sir. So with this, we are over with our question answer session. So I would request Viral Dave ma'am to proceed with the next segment. Over to you, Viral ma'am.
Thank you, ma'am. Am I audible? There is a problem with my bandwidth.
No, you are audible, ma'am. Yes, ma'am. Yes,
thank you. Yeah, ma'am. Now I request our principal, Dr. Shweta Wadhwani, ma'am, to kindly address the gathering and give concluding remarks. Over to you, ma'am.
Am I audible?
Yes, ma'am. Yes, ma'am.
Okay. A very pleasant evening to our today's esteemed guest speaker, Dr. Santosh Shah sir. Our tomorrow's distinguished speaker, Advocate Anand Patwardhan sir, who have joined us today. All the participants who have joined today's webinar, including my dear students and our whole KES team. We are very fortunate to have such powerful speakers with us today. I also agree with the thought of Sri Mahatma Gandhi ji that we are all consumers throughout our life till we leave this world. Hence, it is significant for each one of us to have certain knowledge on consumer laws. Hence, today's webinar was organized. Sir, your presentation, the videos you shared captured attention of all of us. Your words were truly informative, which took us throughout the journey of consumer laws, its lacuna and landmark judgments. It was a delightful journey, sir. We are now eagerly waiting for tomorrow's webinar, which will enlighten us on the various lacunas and amendments related to consumer protection law. Once again, thank you, sir, for being with us today. Thank you, Patwardhan, sir, for joining us today. And to all my participants who have joined in this webinar. Thank you.
Thank you.
Yeah, thank you, ma'am. Now I request our staff member, my colleague Pooja ma'am, to kindly give a propose a vote of thanks. Pooja ma'am, over to you.
Pooja, unmute yourself. Pooja, unmute yourself. Hello.
Can we unmute Pooja ma'am? Shweta ma'am, can we? Shweta,
yes, ma'am. Yes, ma'am.
Yes, now.
Please unmute. Yeah.
Hello, am I audible now?
Yes, ma'am. Yes, ma'am, you're audible.
Yeah. Good evening to Honorable Guest Speaker, Advocate Dr. Santosh Shah sir and Advocate Patwardhan sir, respected Principal ma'am, and my colleagues and all the participants. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of KES Sri Jayantilal H. Patel Law College, would like to extend a hearty vote of thanks to our Honorable Guest Speaker,
keep the national
Advocate
anthem ready,
Dr. Santosh Shah, and even Advocate Anand Patwardhan sir, who has joined us today. I would like to thank Advocate Dr. Advocate Santosh Shah sir for blessing us with his presence by taking out the valuable time from his busy schedule. Sir, the way you mentioned the topic today was proficient and exemplary. I would also like to mention a deep sense of appreciation for your versatile work in the field of law. Thank you, sir, once again for sharing the knowledge with us. I must also thank our KS management for the constant encouragement and support. I would like to express my kind gratitude to our principal ma'am, Dr. Shweta Vadvani ma'am, for constant guidance and support in organizing such events. I would heartily congratulate to all the participants for the active participation in this event. Last but not least, as no program can become successful with a single person, so I extend my big thanks to my colleagues for their support. Thank you everyone for making this event successful with your contribution. Thank you.
Thank you, Pooja ma'am. Thank you, Anand sir. Thank you, Santosh sir, for your lovely presence and elucidation of the topic. Now I request everyone to kindly stand and raise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
With this, we have come to an end as far as today's session is concerned. So I draw the curtains as far as the day 1 of the webinar on navigating complexities of consumer laws in India is concerned. We look forward for the participation for day 2 as far as tomorrow is concerned. We'll be starting the session at 4 o'clock tomorrow. So thank you. Thank you again, Santosh sir, Anand sir, Shweta ma'am, and all my colleagues. Thanks a lot.
Thank you.
Yeah.
Thank you so much, sir. Thank you, Patwardhan sir, also, sir, for joining us today. Thank you, Shah sir, sir. Your words were really informative. We have learned, we have learned this particular laws at the time when we were doing or we were going through that college phase. And after that, although we have gone through that, but not in so much detail that you have covered up today. So we are really enlightened today.
Thank you.
It was a very informative session, sir.
Thank you for the
Thank you so much.
Thank you.
Thank you, sir. Thank you, sir.
Thank you. For feedback form, Viral, you need to
tomorrow, ma'am, we'll be sharing
tomorrow,
the Since it is a 2-day webinar, the feedback link
tomorrow only we will do. Okay, no problem.
Yes.
Okay.
So the participants are requested to leave the meeting as tomorrow we'll be sharing the feedback form.
Yes.
Thank you so much.
Ma'am, I think we can end the session.
Yes. Shweta ma'am, we can end the session. Who is this Oppo A31? The person is still there. Can you unmute yourself and tell me who is it? I see Oppo A31. Can you put in the chat box? Yeah.
Oh, no one is answering, ma'am.
Every join here. Okay, ma'am. We can. Shweta ma'am, we can leave.
Yes, ma'am. Shweta ma'am, सेशन एंड कर दो. हाँ, पाठक मैम.
हाँ.
अभी वो मीटिंग एंड कर देंगे तो
हम लोग we will leave.
Yes, ma'am. Yes, sir.
Yes.
We will leave. Yes, ma'am. Okay, ma'am.